Hi, good afternoon, everyone. Welcome to immigration.com, the law offices of Rajiv S. Khanna, PC. This is Rajiv. Today is January 11th, 2018, our first call for this year. We have a community conference call for everyone every other week on a Thursday. First, I will go over the list of questions that have been posted, and I consider them to be frequently asked questions. Once I finish those, then we'll deal with the other posted questions. I don't think I'm going to have time for new questions, but you're welcome to ask questions related to what I'm discussing when I call for it. That said, do follow us on social media, Facebook, Google+, LinkedIn, Twitter. All the links are on immigration.com top right. When you go to our website, you'll see the social media links right there. We try to keep people informed and also review my blog, which is at the bottom right on immigration.com. Okay, that said, let's begin with the questions for today. I'm going to go to the first frequently asked question. This is about submitting adjustment of status form I-485 when an applicant is in between projects that is not working. Okay, well, if you are talking about a 485 based upon a PERM application, see, national interest waiver and EB-1A is different. You don't really need an employer for those. But any green card where you need an employer, you definitely need an offer of employment from the pertinent employer. Okay. So the question here is, must the primary applicant be on a project? My husband is a consultant on H-1B. Employer filed the green card. Should my husband be in a project during the 485 submission? There are like 10 different issues here that I can see. Okay. First of all, under the current rules, nobody should be out of a project while they are on H-1. Number two, if you are in between projects, it definitely casts doubt on whether or not there is a permanent job available. Of course, an argument can be made that a permanent job will be available by the time the green card is approved, but it definitely does call into question the genuineness of a permanent job offer, which are the grounds for a green card. Now, you don't really need to be on the job. So let's say if a future employer filed for your green card and when you're ready to file your 485, they are still there with a offer letter, a genuine offer letter that says, okay, we have a job for you. Come and join us before or after you get the green card. You can file with that I-485. But the company that sponsored you for perm-based cases, rules are different for different kinds of employment-based petitions. But for perm-based cases, I think it's problematic if you're in between projects. But definitely, you need an employer's permanent job offer to file the 485. So in your case, if the husband is not in a project, then it raises those two issues that I mentioned, whether the job is permanent and how is it being sustained on an H-1B visa, because you cannot be out of a project. If you are getting paid, okay. But that does create certain amount of uncertainty in this scenario. Okay. But if all those things are taken care of, have a discussion with their lawyers, then you can definitely file even though he's in between projects. One example of it is, what if your husband has taken a leave of absence? Now don't just make up a leave of absence. If genuinely your husband has taken a leave of absence, I don't think that stops him from filing an I-485. Okay, so the rule is, if you have a perm-based case, you've got to have the sponsoring employer offer you a job before you can file the 485. The sponsoring employer can be present or future employer. *5 if you have a follow-up question on this. *5, press *5 on your phone if you have a follow-up question on this. Okay, I've got one so far. And this is from New Jersey. New Jersey, go ahead, please.
Hello, Rajiv. The question was from me, so I do have a follow-up question. And yes, you are my attorney, so I think it will be easier when we start filing the case as well. But when you mentioned it could be current or future employer.
Hang on. If we are your lawyers, why are you posting in the community conference? Just send me an email. I'll call you back. Okay.
Okay, I did speak to someone and they said I could attend this. I forget her name. I couldn't get to Suman. She was out of office during the holidays. I did speak to somebody and I forget her name. So she said I should just post it here and that's why I'm here.
Okay, no, you shouldn't. Of course, I'll answer the question because you have access to me directly. My email is help@immigration.com. You should have that. help@immigration.com.
Okay, perfect. Yeah.
But go ahead.
I'll remember that.
Yeah,
okay.
Go ahead with the question.
So the question is, you mentioned about whether it could be the current or a future employer. So the current employer is the one who's the petitioner. So this is a perm-based EB3 employment-based green card. And the current employer is the petitioner. So when you say it could be a future employer, you're saying some ABC company could still give an offer, and based on that, we could still file 485 for this priority.
No, not at all. I'm glad you asked that question because that's a very basic misunderstanding. Let's begin with how it works. So how is the perm filed? The perm case is filed based upon an offer from a company, and the company files your case for you. That company who offered the job and offered the perm is the one who must also provide a letter confirming the availability of a job when you file the I-485. The reason I said a future job because perm can be filed by a current employer or by an employer in the future whom your husband intends to join before or after the green card is approved. So the job offer has to be from the sponsoring employer when you file the 485, but the sponsoring employer can be the present employer or the future employer.
Or the future. Okay, got it. Okay.
Anything
okay, perfect. Thank you so much.
Oh, you're welcome. Good luck.
Thanks.
Okay, so now the next question is the one that has been weighing down on a lot of people. Set of two questions about H-4 EAD rules change. Oh, I just saw a typo. I'll fix that. H-4 EAD rules change and H-1B extensions rules change. Well, as you folks have probably found out by now, if you are following the social media, and I encourage you to follow us also in addition to whoever else you're following, go to immigration.com and you can follow my blog as well as Facebook, LinkedIn, and Google Plus. Am I missing something? And Twitter, of course. All of those, I keep people informed on what's going on. And I had posted a couple of detailed discussions, and we are still following up on the questions. People post questions and we respond on how this process is going to work. There are two separate issues. One is, are they going to revoke the H-4 EAD rule? And they're going to try. In February, we expect to see a proposed regulation from the government which will overrule the H-4 EAD regulation. Remember, if there is a regulation, it cannot just be cancelled with an order. It has to go through another regulation. And what is the process of regulation or rulemaking? Government has to first post a notice in the Federal Register. That notice usually gives 30 days at least, normally 60 days for public to respond. Then all of us post our comments saying, well, this is a bad idea and this is what you're doing wrong, etc. Then government has to go back and look at all the key comments, address those comments, and then they have to publish the final regulation. If the regulation is based upon illegal criteria, we can challenge it in court and try to get an injunction against its running. So, in other words, don't overrule our H-4 EADs. H-4 EADs, if they do cancel them. Some of the questions that were being asked under our follow-up questions on various social media and my blog were, what happens to the existing EADs? I think they will, again, this is a guess. There's a limit to how far the government can go, and there is also a limit to how far they should go. If they have already approved an EAD for 2.5 years or 3 years, I don't think they should cancel that. If they cancel that, I wonder if I can go after them for the filing fees at least. So if 130,000 people have filed for EADs and they are trying to cancel those that were approved but not fully used up yet, I think they should at least return our filing fees. How about people who have, based upon their expectation of the EAD, taken on businesses, franchises, etc.? I'm not sure that's going to be an easy standalone reason for the court to reverse the regulations, but I think it looks really bad for the government. It really hurts people, because our government should have a certain element of consistency. They shouldn't be changing their mind overnight, and this is pretty much overnight, giving us a few days notice. So we'll see what happens, but it has to go through rulemaking. I'm not sure how it is going to be implemented. All of that is up in the air right now. But it's not going to happen overnight, in the sense that today they send an order saying tomorrow onwards you can't work. They cannot do that. They have to go through the rulemaking process. On the H-1B extension rules change, but before I get there, maybe I'll just combine the two topics. So be ready to ask your questions if you have any. For the H-1 extension rule, what Trump administration had been thinking was that, oh, we'll stop extending H-1 beyond 6 years. I looked at the statute. I don't think they can do that. The 1-year rule appears to be mandatory. It uses the word shall extend. Now, of course, shall can sometimes be considered to be permissive or future oriented. In the future, we shall do this. But in the total context of the statute, I think it pretty much imposes a duty and an obligation on the government. They can't change the statute by themselves. The statute, the law, can only be changed by Congress. The 3-year extension provision appears to be permissive. It uses the word may, but I don't think even that can be taken away by the government easily. So if they try to take away the right to extend H-1 beyond 6 years, they will, I am quite sure that they will lose. They won't be able to do it. So we are pretty, in my view, we are pretty safe. I saw somebody had posted to me some very nasty comments by some organization that said, oh, lawyers don't know what they are talking about. Well, most of us who've been in this work actually went through a fairly lengthy amount of schooling, and some of us have been practicing for 2-3 decades. I do think that we know what we are talking about. But of course, laws are complex and they are uncertain. There are lots of things that can happen. Nevertheless, I don't believe H-1 extensions are in any substantial jeopardy. H-4 EAD could be in jeopardy if government can articulate reasons why they are changing their mind on the regulations that they had posted earlier. Okay, *5 if you have any follow-up questions on this. Oh, by the way, before I get there, you can raise your hands, but let me just finish reading this. There are 3 different people in this. So they wanted to know, there was a rule about strengthening the H-1B non-immigrant visa classification program. Well, I've already discussed that regulations, until they are posted, proposed regulations, they don't really mean anything. Regulatory agenda is just an agenda. It is not implemented yet. Next question was from Deep Impact, who said, I've completed 6.9 years on L1A, moved to H-4 EAD based on my wife's I-140. Now the H-4 EAD may go away. How can I stay and continue working? Because you're already almost past the point where you can get your H-1 extension. What you could try doing is have your green card started, and that can, hopefully by the time your H-4 EAD comes close to being taken away, your green card has been going on for a while, and you can use that to extend your H-1. Okay. So that might be a way to do this. You've completed 6.9 years. Now remember, anytime you are outside on L1A, I think that can be recuperated. I'm pretty sure it can be. Because in the H1 context, this was made clear. I would suspect that the L1 is very close to the same recuperation policy. I believe H1 can be applied only 6 months prior to joining that job. You see, the problem is you don't have any time left on your H1 because you've taken 6.9 years of L1A. I think you can only do this if you start a green card process. Can company file green card for me now and apply H-1B in April? No. The 1 year extensions can only be applied. I'm trying to remember. There are different rules for 1 year and 3 year extensions. No, 3 year extension is actually is pretty clear. The 1 year extension can be applied. So let's say you filed your green card today. First of all, H1 rule is you can file for H1 extension 6 months ahead of time, right? So let's say October 1st is your start date and you start your green card, you filed your green card on October 1st of the previous year, October 1st, 2017, then you can actually file your H1 in April even though you don't currently have 1 year on your green card pendency, but the start date of your H1, which is October 1st of the following year, would be when you have 1 year pendency because of the green card application you started last year in October. So yes, in that circumstance, you could apply in April and take your chances under the quota. I hope that makes sense. And then Kumar had a question about they are thinking of revising the definition of employment and employer-employee relationship. What is your interpretation of employer-employee relationship? I don't think they can go any far below what they've already gone. The only thing I think they can try to do is they can try to hurt the so-called outsourcing industry by defining employer as somebody who just manages you on a day-to-day basis, not based upon the right to control, but based upon the actual control. So we'll come to that. Well, when we come to that bridge, we'll cross it. Right now, I don't know what they are thinking. It hasn't been made public yet. So I already said press *5 on your phone if you have follow-up questions. I'm going to go to the first follow-up question. *5. Okay, Minnesota, go ahead, please, Minnesota.
Hello, Rajiv.
Hello.
Can you please repeat the few words that you were talking about H480 initially about something like regulation in February?
What the government has said is, there was a lawsuit going on and the case got thrown out, I should say. It got thrown out on a basis of standing, and then the Save Jobs USA took an appeal against it. The appeal was pending. There was a hearing in that case, I think a week or so ago, where the Trump government came in and said to the court, we are going to revise the regulations and we are going to start that in February. So that's what they told the court. So we are expecting that in February, Trump administration will publish new regulations which will try to take away the H-480.
Okay, got it. Thank you.
Okay. Let's go on to the next one, which is, let's see, Texas. Texas, go ahead, please.
Yeah, Rajiv, this is Deep. So, as I explained, I completed almost 6.9 years. So what option I have? If some company start GC for me and says approve in another 7-8 months, 140, then again I have to go. So I never was on H1. So there is no way
you have to.
I talk about that selection.
You have to go through the quota.
Yeah.
But
okay.
Because your I-140 is already approved, you should be entitled to a 3-year H1. But that doesn't mean you're exempt from the quota. You still have a quota issue. Okay.
So, though I completed almost 7 years, and now I start my green card processing, then also I can apply the company can apply the H1 for me.
I think the rules are not really meant to cover this situation, but I would certainly argue. You see, what I would argue is this. Let me think. Question is, if you have, and this is not something I have to actually look up the law. On L1A, you can do 7 years. On H1, you can do only 6 years. So if somebody has done a little bit less than 7 years, do they have some right to extend an H1? I don't know. I don't think so. But let's assume that you do. And even if you have 1 month left on that, I would say that if you can seek H1, then you should be able to seek extension as well, which is based upon your I-140 approval. Now the question is, what if your 6 years of H1 are no longer available because you used your L1A 7 years or almost 7 years? Can you still get an H1 extension beyond 6 years, in your case 7 years? And my answer is it's worth a try. I don't think there's a clear-cut answer in the regulations on this. I'm not aware of it. I would have to review the regulations, review the decided cases, and see if there's anything that points me in one direction or the other. But I think it's worth a shot.
So one person like I was on L1A and my company started the green card processing, collected the document for EB1. But suddenly due to all these changes, they have stopped. So I work in the same company for last 13 years, but right now I am the H4 EAD. So since I am on H4, can they again restart my EB1 or they cannot start?
Oh, absolutely. They can start your EB1A. No question about it. Okay. Actually, not, I'm sorry.
H4 and that doesn't matter.
I'm sorry, let me rephrase that. It's not EB1A, EB1C, based upon international manager executive position.
Correct. So, like visa type doesn't matter, right? Even I am the dependent visa H4 EAD, but still they can do EB1.
The law is that you must have held an executive or managerial position for 1 year out of the last 3 years outside the USA. But if you are in the USA already working for that company, then, and this is how I remember the law, then the 3 years are counted from the date you entered the USA. So when you entered USA in, let's say, 2011, and you stayed working here till 2017, if we were to file green card today, and if we look back at last 3 years, you haven't worked for them outside USA. So the law says if you're working for the same group of companies, we look at the 3 years before you entered USA. So between 2008 and 2011, if you worked for 1 year outside USA for this group of companies, you are good as gold for the green card. And I think the same rule would still apply. You should be able to file an EB1C based green card if your company so wishes.
Yeah, because like now I talked last week because of after this rule came, telling you were on L1A, but right now on H4, so you're not any more on the managerial visa. But I don't like I was managerial. Yeah.
I don't believe that to be true. I think they should look at the regulations again. Okay. All right.
And last question on same thing. Suppose like if they stop H4 EAD, say maybe another 2-3 months, and my EB1 takes longer time. So in that case, I can be in the US, right?
If you have your 480 filed, the answer is yes.
Okay. Okay. Thank you so much.
You're welcome. Good luck. Okay, so we are done with this. Let's go on to the next frequently asked question. So this one is about change in job title after getting a green card approval. Somebody came in on a green card as a programmer analyst and then changed to architect/project manager. Similar job duties as my green card employment offer letter. At the time of US citizenship, is this going to be a problem? Well, I can't answer that question with a simple yes or no. We would have to look at your job title and job description, which is the more important part, and see what the job description in the green card is and how different it is from the position that you took on. Unfortunately, for consular processing people, we don't have that same law, the AC-21 same or similar job law. So I cannot really comment that this is going to be or not going to be a problem. I don't think it's a clear-cut answer, unfortunately. Generally speaking, if you are going through adjustment of status process and your green card has been 485 has been pending 180 days, your I-140 is approved, that means you're covered by the AC-21 rules. In those circumstances, a change in job title to a same or similar job is not a problem. So I had a case today I was looking over. Somebody had a green card job as a database administrator, but the next higher job they were getting for green card was data architect, and they are same or similar jobs, so I don't think there's going to be a problem. So it all depends upon the posture of the case, how it was filed. Generally speaking, job titles are not that important. Job descriptions are much more important. *5 if you have a follow-up question. *5. Okay. Let's go on to the next question. What did I do? All right. April Wilson. Wow. Transferring H-1B while an RFE is pending. So if somebody has a request for evidence during an H-1B extension, can they transfer to another employer even while the RFE or its response is pending? And the answer is yes, of course, but there are two situations. One situation is your company applied for your extension, let's say 6 months ahead of time. In the second month, they got an RFE. It's pending now, but you still have 4 months on your original H1 still left. During that time, you can transfer, there's no question. But what if your status has expired and the transfer is pending? You can still transfer, the extension is pending. You can still transfer, but you may have to go outside for visa stamping if on the date your transfer is approved, your extension is not already approved. If the extension is denied or still pending, government can say, well, you have to go outside USA for visa stamping. *5 if you have a follow-up question on this. Press *5 on your phone if you have a follow-up question. Okay. Let's see. For some odd reason, my machine seems to have mysteriously slowed down. Oh well. Let's see. This was another frequently asked question. So I want to do an online degree or a degree to ensure that I can file an application under EB-2. How do I find out whether or not my degree or my university is accredited? And I've pointed this out to you before. I actually have a blog entry on this also. If you go to my blogs, I actually showed you how to do it, but I'll give you the theory of it. Basically, the way that the education is accredited in the United States is this. You can have, this is what I understand, your degree can be accredited or a particular school can be accredited. So let's say you want to look at the accreditation of your program. First, you will go to the Department of Education, US Department of Education, and see which agencies in your state, the state where the university is, which agencies, usually 1 or 2, are authorized to accredit programs. So once you do that, then you go and check on the school website or check with the school who has accredited your program. And if the program has been accredited by an agency authorized by the Department of Education, U.S. Department of Education, to do so, then you know for sure that the degree is accredited. Okay, I hope that helps. So U.S. Department of Education maintains a list of state level agencies who can accredit programs, and your university should be able to tell you who has credentials or accredited them or their programs. Star 5 if you have a follow-up question on this. Star 5. Press star 5 on your phone. Okay, I think these are all the frequently asked questions. So let's go on to our regular questions now. Wow, my computer has, and this is actually one of the best hardware pieces available. Huh. Okay, well, it is what it is. Now we start with a list of questions from our community members. The first one is, well, this is from Amit Ranjan, who says, look, when we do the LCA, it is for that particular year, but Department of Labor keeps changing their wages every year. Does the employer have to do something about that? The way I understand the law, I haven't looked at this issue because it hasn't come up. I believe that this issue was considered by the government, and they believe that the existing regulatory framework is sufficient. How? One, when the employer files, they are required to use only the LCA wage or the actual wage, whichever is higher, that is available at that time. If the next year the wages go up, that means in their, unless they're not giving raises to their workforce, if the wages in their workforce for similar jobs are going up, they are supposed to give the H-1B people a raise as well. They can't keep you behind. But from what I recall, there is no requirement that each year the employer has to recertify the LCA. There is no such requirement. Star 5 if you have a follow-up question on this. Star 5. Okay, let's go on to Jay Vijay. They say candidate is in H-1B for 7 years, got I-140 from employer A. 8th year he got his compelling circumstances EAD due to medical condition. Then 9th, 10th, 11th, 15th year he gets his compelling circumstances EAD. 16th year he can no longer extend due to his priority date becomes current. He exits USA. Can he come back to USA on a new H-1B visa through employer A, or can he come back through any other employer? Well, there are more than one issues here. I'm not sure I've thought this whole thing through. But first of all, first issue is he subject to the quota? Because what would prevent him from being subject to the quota? If his H-1 was approved within the last 6 years. It looks like it is not. 1, 2, 3, 4, 5, 6. It's been more than 6 years since his last H-1 was approved. So I'm not sure he's exempt from the quota. I think he is subject to the quota. But if he were not subject to the quota, let's say he left in the 2nd year after the EAD, then as long as his I-140 stayed approved for 180 days past January 17th, so even if January 17th was the 180th day, as long as it was 180 days on January 17th or later, you have the right to extend H-1 through any employer using the I-140 through this employer, even if the I-140 is revoked by this employer. So can he come back to USA on a new H-1B only through employer A? Given the discussion I just had, the answer is no. Can he come back through any employer? Yes, he can. Is the I-140 from employer A useful? Very much so, for 2 reasons. You get your priority date, you can get your green card started again and get the same priority date. And 2, if it stayed approved for 180 days, you can keep getting extensions with But if the priority date is current, then you can't get 3-year extensions. You can get only 1-year extensions. *5 if you have a follow-up question. *5. Okay. Let's go on to the next one. Guys, immigration law is very, very complex. No matter how hard we try, it is not something that anybody can say, oh, I know all the answers. I spend so much time studying and reading. There are still things I learn new every day. Kumar has a question. Completed 6 years on H-1B. Approved I-140 for more than 180 days EB2. I want to quit the company, go back to India for 3 to 5 years and come back again with a different company. In this case, is there any consular processing required to get the visa and H-1B petition, as everything will be expired? Basically, when you want to come back, you will have to get an H-1B filed, and if your H-1 was approved in the last 6 years, you would not be subject to the quota, and you should be able to get a 3-year H-1 extension based upon the approved I-140. You can also start your green card. You'll have to, but you'll carry the priority date of the old green card. Okay. *5 if you have a follow-up question. *5. Let's go on. Come on. Wow. Bear with me for a moment, guys. I'm trying to, for some reason, my computer is giving some trouble. There's a post from Chris Martin about DV lottery. Sorry, we don't do DV lotteries. No idea how that works. I don't know where I was. Okay. Boy, this is getting so slow. You know what? I might just open another computer. Give me a moment, folks. I'm gonna just open another machine. That might be easier. Yeah, this machine just doesn't want to go faster than this. And I don't want to close and reopen this. Okay, so yeah, that's 1,000 times faster. So we did this question, Jai Vijay. We did a question from Kumar. Now we are doing a question from Dan. Dan has an issue that they responded to an RFE and it's just been sitting there. There is no action on it. So what should they do? There's a birth certificate. Well, Dan, if you're asking me, can you hurry along the process of an RFE determination, then the answer is probably not. If you feel that it's outside the published times that they have, you can contact and open a service request, and this is the one I'm answering. So you can also open an ombudsman's request. So if you go to the search engines and type USCIS ombudsman, it tells you how to open a request. You can try following that, but really there is not anything useful I can tell you other than to wait and try these two things: service request, failing which ombudsman's request. *5 if you have a follow-up question on this. *5. Okay. I already answered April's question. Shobit Joshi has a question regarding change of status from H-1B to H-4. Wife's situation is a little complex. She's on H-1B. Older petition expired on December 13th. I don't know what that means. You mean 6 years, okay. Completed her 6 years on H-1B. Her company filed for extension based upon approved I-140. Got an RFE, they are responding. In the meantime, she might get fired, okay. Can she file for change of status from H-1B to H-4 when she's in the 240-day period? No. The 240-day period is only for those people who need work authorization while their timely filed extension is pending. It does not give her the right to file for a change of status. She'll have to go outside for a visa stamping. She can go to any country, doesn't have to be in India. And the question is she out of status right away? And that has changed a little bit. There's now a 10-day period or a 60-day grace period, depending upon what your particular situation is. So she won't be out of status right away, but she should travel out and get an H-4 visa stamping if she wants an EAD. She can come back and apply for an EAD. How far that's going to go with the upcoming change in regulations anticipated, I do not know. Star 5, if you have a follow-up question on this. Star 5. Okay. Then the next one is also from April Wilson. Guys, try to keep one question so that other people can also log in their requests. My sister filed for H-1B extension before expiration of her current H-1B. Extension was pending. She left USA, went to Canada. The employer withdrew her H-1B on November 2017. Is she out of status from June 2016 to the date she left USA? No. While a timely filed extension is pending, she's neither out of status nor unlawfully present. Okay. So my sister filed for H-1B extension before expiration of current H-1B. Her H-1B expired, valid EAD from October 2016 to October 2017. She left USA. So anytime, I'm not sure I follow all the facts, but anytime a timely filed extension is pending, the person is not out of status. So even if they leave USA, that does not somehow go back and make the time that they were staying in USA with a timely extension pending, an old petition having been expired, it doesn't make that illegal. So as long as you have an extension pending, you are not unlawfully present as long as it's timely filed. Star 5, if you have a follow-up question. Star 5. Okay. Aku1993 had sought my advice on F1 visa. Unfortunately, I had 3 F1 visa rejections since August. I want to do an EB5. No, EB5 will not have any bearing on your earlier F1 rejections unless there is fraud. But 214B is based upon immigrant intent. So when you're filing for an immigrant visa, that shouldn't be a problem. And you said, if while in the process of EB5 visa I get married, can I add my wife's name? Yes, of course. In approximately how much time can EB5 application get processed? Well, last time I checked, they were taking a couple of years just to process the first form, then another few months to process your green card, temporary green card. Can I suggest an EB5 lawyer agent in India? No, sir, I cannot. Any follow-up questions? This press star 5. Star 5. Okay. Chris Martin, I already told you we don't do DV cases. Okay, there is a follow-up question. Virginia, go ahead, please, Virginia.
Yes, sir. Can you hear me?
I can hear you. Yes, sir.
Yes, sir. My name is Mohammed.
Ji.
And, sir, I came on a K1 visa.
Okay, hang on. Hang
3
on.
years ago.
I'm sorry. I'm not going to have time.
Okay.
I'm not going to have time for new questions. I said that in the beginning. I can only do follow-up questions. You can try posting for 2 weeks from now, but post ahead of time so I'll cover your question. Okay?
Okay, short question, sir.
Can't do it.
Okay, I
can't do it. Don't have time. Okay, next question. That's why we have the discipline of posting questions ahead of time. Jay says, my wife had H-1B from 2007 quota. Her last H-1B was valid from August 2010 to October 2012. We have converted her status from H-1B to H-4 in July 2012. Okay. H-1B was used only for 3 years. Is it possible to go back to H-1B cap exempt? And the answer is probably yes, if you file very quickly. Why? Because if we consider her H-1 period to be all the way till July 2012 when she converted to H-4, as long as you get her case filed before July now this year, I think government will consider her to be exempt from the quota. If Trump administration changes their interpretation and says, no, it's not 2012, which is the termination date or the date she went out of her H-1 status, it's 2010 when we first approved the case, then she will not be eligible to be exempt from the quota. So my advice is hurry up, file, take a chance. I think it'll work. *5 if you have a follow-up question on this. *5. Okay. Let's see. Oh boy, this system doesn't want to move. So let me go to the other computer. Now we are talking about all right, F1 visa, we covered that. Prasad 121 asked me, oh yeah, here he is. Is there a new rule proposed that would prevent people from extending H-1B status beyond 6 years? I already discussed that in the beginning and clarified that. So listen to the discussion. This one is in a large font. I had one arrest for 20 minutes, court dismissed the case, issued the expunge order, removed my information. 2 years, they reposted the same information. What does that have to do with immigration? I'm not sure this has anything to do with immigration. I'm sorry, I don't have any idea. That's not my field of expertise. H-1B visa rules, that is more my area. You said, what do you think about the news? I've discussed this in detail, Mira. So if you listen to the discussion in the first 10 minutes of today's call, you'll get all that information about H-1Bs and H-4 EADs. Then we have a question. My H-1B petition was approved. This is from Rich ML. Approved on December 18, 2017. I have a valid H-1B visa stamp in my passport good till July 2019 from the previous job. I work for a consulting company. My client terminated the project in Jan 2018. If I get married in Feb 2018 and my then wife needs an H-4 visa, do you see any potential issues in getting an H-4 visa stamp? My understanding is that I do not need to get a new H-1B visa stamp due to change in job. Yeah, that's correct. Since I would be getting married in India in Feb 2018, I'm thinking of coming back on visitor visa and find a different job. Oh, I think that's a very bad idea, because looking for a job is probably not an acceptable purpose or use of using a tourist visa. I foresee a lot of problems with that. And I think that Getting an H-4 would be difficult if you don't have a job already on H-1 in the United States. Star 5 if you have a follow-up question on this. Star 5. Okay. Folks, I still have about 11 minutes before I have to ring off. So let's have you raise your hands, star 5, and I'll do as many questions as I can. Press star 5 if you have a question. I'll try to do as many questions as I can in the next 11 minutes. Let's go first to Virginia. All right. What's happening? In the order that you folks logged in, oh man, this system has become so slow. I don't know what to do. You know what? Let me just open the whole discussion to question and answer.
The conference is now in question and answer mode.
Just press star 5 to ask me your question. I'll take the first one first. Press star 5. Go ahead. Go ahead.
Hi Raju.
Hello.
For N400 application, received a letter to submit additional documentation that says submit certification of filing of federal income tax returns and state verification of filing of state income tax return. So what does certification and state verification mean in this regard?
You're going to have to talk to your accountants, not my field. My knowledge of tax laws is almost zero. So whatever the documentation is, they should be able to help you with that. Talk to your CPA, okay?
Okay. And when they request W-2s issued by IRS, is it like we need to submit the originals or the Xerox copies?
You're going to have to talk to your CPAs. I'm pretty sure if they say issued by IRS, they probably mean some kind of a certified documentation.
Okay. Thank you.
Good luck. All right, star 5, next one. I think there's one more question. Well, very good. I think we are done for the day. All right, folks. Thank you all for being here. I'll talk to you again in 2 weeks. Oh, there's one question. Let's see. You should be able to talk. I put you on question answer. Say hello. Say hello. No, you're not able to talk. Okay. I just unmuted you. California. Give me a second. For some odd reason. Yeah, go ahead. California, go ahead. California. Hello. I don't know what's going on, guys. I can see you. Okay, I think it looks like a system issue. I can see a couple of other people have questions, but I can't get to you. Do me a favor, guys. Everybody just put yourself on mute, okay? I'm going to just open the conference. Maybe we can talk that way, if I can get to the conference. Nope. I can't. Okay, let me stop the recording. Let me stop the recording, and I'll stay on the line, and I'll get to you guys. Maybe the recording is taking a lot of the system resources. All right, folks. Just stand by. I'll be right with you. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your
iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.